But the question is whether the court addressed the question of whether the Second Amendment applies to the states. When you're dealing with the District of Columbia, obviously you're not dealing with a state per se. And there's a question, I would take it, with respect to whether the Bill of Rights, which originally were adopted for the purposes of constraining the new federal government, whether that provision of the Bill of Rights would be incorporated and applied with respect to the states, given the prefatory language that you read, which the court concluded was not sort of a sufficient basis for narrowing the context of the right itself, but indicates that the purpose of the framers was to protect the security of the free states. Is there a question that remains then about whether that protection would then apply and bind the states themselves or only apply to the federal government?
Very good question. Justice Scalia said in a footnote specifically, we're not resolving that here. He cited some old 19th century precedents that said, no, it does not apply to the states. But he also noted that in the 20th century, the court had applied amendment after amendment after amendment from the Bill of Rights to the states, had said they apply through the adoption of the 14th Amendment, and left it open whether that would happen here. And if it's not applicable to the states, it really will mean very little, because the federal government isn't passing the sort of gun control laws the court would strike down, so it's just about Washington, D.C. If I had to get, most of the commentary I've seen kind of charges right ahead to say, well, Chicago's next, New York, Detroit, and seems to proceed on the assumption that the court will eventually apply it to the states. If I had to guess, I'd guess that's true, but I wouldn't bet too much on it.
But it's at least a great argument for Chicago to start with, that the entire decision doesn't apply to us.
Well, I don't know how great it is.
Well,
I mean, it is an argument. I mean, one of the things about, the point that Randy made is that, this notion as to whether the Bill of Rights, which was intended to bind the federal government, ultimately ends up applying to the states, is based on the intervening passage of the 14th Amendment right after the Civil War. And the question is that was such a change in the federal-state balance that many of these rights, those that are sort of implicit in ordered liberty, as the phrase goes, really now applied to the states. And I would make 2 points in response. One is that contrary to the implication from Randy's question, in applying a part of the civil rights to the states, the Supreme Court has not been very punctilious about looking at the language of the particular constitutional right. The first one that was ever imposed on the states, I think, was the First Amendment, which starts with the words, Congress shall make no law. And the second point is that if you read the discussion that Justice Scalia engaged in, and part of the reasoning as to why this always has been implicit in a right to self-defense and his discussion of the freed slaves after the Civil War, you get a fair amount of fodder for the proposition that if something was incorporated as part of the war over slavery, certainly it would be something that would be intended to give the recently freed slaves this right.
I'd like to toss a related question back at you, Ben. Since expansive interpretations of the Bill of Rights, including against the states, have traditionally been kind of a liberal thing, and dragging feet on this has traditionally been kind of a conservative thing, what will the vote be on the court? Who will vote which way on this issue when it comes up?
Well, I feel totally unqualified to answer that question. That said, I actually do agree with Miguel that this is not a winning argument for Chicago, and I think I think it's going to take several years to find that out, because it's a good issue to litigate. But at the end of the day, I think it would be very hard for the liberal justices to say, we incorporate all the provisions of the Bill of Rights against the states, except for the few isolated ones that really don't make sense, and the Second Amendment, which we kind of don't like the substance of. And I think it for exactly the same reason, I think it it's kind of an empty thing for the conservative justices to say, well, we've pronounced this grand new right, only it doesn't apply against the only sovereigns that are likely to want to use it the only sovereigns that are really likely to want to restrict it, which is to say the state governments. And so I think you probably have a pretty broad consensus for the idea that whatever the parameters of the individual right is, it probably applies against the states. But
yeah. Well, let me say one word about that, and I probably ought to then turn
okay.
to the other cases. But we probably could spend the whole time on this, given how interesting it is. But in response to that point and to Miguel's point, the Second Amendment is the only one of a provision in the Bill of Rights that actually specifies in its text its purpose. And in doing so, it says that its purpose is in order to secure a free state. And if one is a textualist and is studying that language and then is applying the standard for application of those restrictions and liberties to the states, one then asks, okay, did the framers think, and is this provision a provision which is necessary to ordered liberty? Is there something with respect to the liberty interest in the relationship between an individual and a state that says that the individual should be able to bear arms? And based on the history, and I'm no expert on this, but what little I know about the history and the language, one would think that there actually is at least a substantial argument that no, the amendment is not about protecting individuals versus the state. It may provide a broader protection as the court has held, but its purpose was in order to provide a protection against the federal government.